Tēnā koutou katoa, and welcome to the 2,500 lawyers who've registered for this webinar. My name is Tiana Epati. I am the president of the New Zealand Law Society, and I will be hosting today's webinar. We're very privileged today to have 6 of our heads of bench joining us to answer questions from the profession. Before I introduce each of them, I just want to remind everyone that this is a very special opportunity that we're being afforded by the Chief Justice and members of the judiciary. It is therefore very important that you don't attempt to record or somehow live stream this webinar today further to your friends or members of the public. I can tell you that an approved recording of this webinar will be made available and a summary of some of the answers that will be given through NZLS CLE after today. So I just ask that you don't try and live share it with your friends who haven't made registration or are unavailable. Just one final detail before we get underway. While the chat box function isn't going to be operating during the webinar, you will have the opportunity to ask follow-up questions using our COVID-19 email, and that's along the bottom of today's slide. We will try and answer those questions at the end if we have time. If we don't get to answer your questions, we will eventually come back to you in some form or another with an answer. So, joining us today is the Right Honourable Dame Helen Wynne-Kelman, Chief Justice of New Zealand, the Honourable Justice Miller of the Court of Appeal and Chair of the Judicial Steering Group, the Honourable Justice Venning, Chief High Court Judge, the Honourable Justice Thomas, Chief High Court Judge Designate, His Honour Chief District Court Judge Taumanu, and Her Honour Judge Moran, Principal Family Court Judge. I ngā kai whakawā te kōti o Aotearoa, tēnā koutou. Tēnei te mihi nui ki a koutou katoa, nau mai, haere mai. Welcome to you all. Thank you very much for making yourselves available and giving the profession this very special opportunity. I just want to take the time now to thank you for the effort, not only that you put into the constant communication with the profession, but certainly all the effort and time you've taken in the lead up to this webinar. We're very grateful for the constant updates that you're providing in what is a challenging and very fluid situation. So now I'm just going to invite the Chief Justice to make some introductory remarks, and that'll be followed by Justice Miller.
Ngā tini hou o te waka Aotearoa. Tēnā koutou, tēnā koutou, tēnā tātou katoa. Thank you, Tiana. I'm grateful to you and to the New Zealand Law Society for this opportunity to speak almost directly to members of the profession. I'm going to begin by giving a brief outline of the steps that the judiciary have taken since mid-March to respond to COVID-19. In taking the various decisions we have over the last 6 weeks, the heads of bench have been concerned to ensure the profession can continue to work in the best way possible in the interests of their clients. For that reason, we have reached out to the New Zealand Law Society and other representative bodies to ensure we hear of concerns, difficulties, and that we receive your ideas. We've also been determined to communicate clearly with the profession just what steps we're taking and why we're taking them. And this is again in the context that at times our decisions have had to be made under great time pressure. I first wrote to the profession on the 13th of March, and if you can cast your mind back to that time, at that time, there was really no thought of something called a lockdown, and we had 7 confirmed cases of COVID-19 in New Zealand. The Ministry of Health was consulted by the judiciary about what was an appropriate response, and they told us that we could continue business as usual, subject to a limitation on large gatherings, which we didn't trigger in any of our formations, and subject to good hygiene practices. But there was a deep concern within the profession as to whether it was safe to come to courthouses. And this concern focused in particular on jury trials. Having reflected on the concern and in light of the very particular nature of jury service, on 18 March, I took the decision to suspend new jury trials for 2 months. This went beyond the Ministry of Health advice, but it was necessary, I judged, to take the steps to protect jurors, counsel, and the public. At this time, as I said, there was really no expectation of a lockdown as a response to the virus, but then things began to move very quickly. And by 25 March, the country was at level 4, alert level eliminate. From the announcement of that level 4 to its implementation was a space of 3 days. And in that time, the courts had to reconfigure their operations to address the lockdown reality and the pressing public health safety need to operate in the way we came to. And this, the judiciary was supported by the Ministry of Justice. And so for those of you who aren't aware of it, the judiciary does not have a control over its over money to provide itself with courtrooms or staff or technology. We depend on the Ministry of Justice for that. So they support the function of the courts by providing us with courthouses, our registry staff, and the technology systems, down to the laptop I'm talking to you on today. When I say we had to reconfigure, I mean that the courts had to transform from a paper-based system, which did most of its work on a face-to-face basis, to a system operating with electronic filing, and when many required for the court's work would not or could not come to the courthouse. This meant a move to a presumptively remote operating model. The need to keep those safe who work within the courts and those who come to the courts has been a pressing concern both for the judiciary and for the Ministry of Justice. Now, I'm pleased to say that to date there has not been a reported case of transmission of COVID-19 related to the operation of the courts. I'd like to say something to explain the constraints that the courts initially had to deal with under Level 4. The court's reconfiguration had to accommodate that a substantial part of the judicial workforce was required to self-isolate because of age or health vulnerability. Approximately 20% of the judicial workforce was stood down because of this, and that hit the district court most because of the acting warrants. The court operation also had to reflect initially that the registries were only staffed at a skeleton level. In the early days of the Level 4 lockdown, the Ministry decided that the registry should have very low staffing levels because they were concerned that those who worked in the registries worked in quite close quarters with each other, and that was a risk. Our reconfiguration also had to reflect the restrictions on movements that applied to the population generally, the requirement for physical distancing within the courthouse, for counsel, for the judge, for anybody who came there, and the need to avoid the movement of those in custody because our prison population is extremely vulnerable to COVID-19 and its spread. However, as I've stated throughout the COVID-19 response, the work of the courts is essential. It's an essential service, as that expression has come to be used through these last few weeks, because of the need to maintain the rule of law. As this audience knows, maintenance of the rule of law does not just require the conduct of criminal proceedings. It requires that people can have their civil rights tested and vindicated. And that's never more important than when a society is operating under a state of emergency. The judiciary therefore said that the courts would remain open whatever the alert level. The courts would continue to receive electronic filing or filing by post, but the public counters would have to be closed. We said, however, that initially only priority proceedings would be heard, and we defined those as proceedings affecting the custody, the liberty of a subject, a person's safety or well-being, or proceedings that were time limited. The day after the Level 4 lockdown, the profession again raised with us concerns regarding the high numbers of public still attending at our courthouses, notwithstanding that they theoretically shouldn't have been moving about. They were coming there to support defendants, and they were coming there in numbers. This was also stretching the capacity of security staff to cope, and duty solicitors expressed the view that they felt unsafe in the courthouse. The heads of bench therefore decided to restrict the numbers of public who could attend, requiring that they seek permission of the presiding judge. This was an exercise of the court's inherent power to control the precincts of the courthouse when necessary for the administration of justice. It was a decision taken reluctantly, but it was taken to enable the work of the court to proceed in a manner which ensured that those who were coming to the courts could be there safely. Throughout, however, we've been concerned to ensure that the principles of open justice are maintained, because they are tested in times when the public can't come to the courthouse. And so for that reason, I asked Justice Mark Cooper to chair a committee whose terms of reference require it to monitor the extent to which open justice principles are observed and to
Right. So we've just lost the Chief Justice for a second there. Justice Miller, I wonder if you could, are you able to pick up the comments from there?
in a position to signal
Oh.
preparedness to expand the work that they were doing beyond priority proceedings. We capacity allowed. That means, for example, that from next week, the High Court's work will go ahead as scheduled, with the exception, of course, of jury trials and of witness actions. All courts are working to reschedule work that has been adjourned over the last 3 weeks, and they're all working to find ways to deal with witness action work. There have been some problems in the implementation of the court's protocols in the last 3 weeks. Some matters where defendants were in custody were administratively adjourned rather than called before a judge, and that should not have happened. However, as soon as it was drawn to attention of the Chief Judge of the District Court, he addressed it and it has been rectified. Initially, some filing, particularly in the senior courts, was rejected, and that should not have happened. As soon as the Chief Judge of the High Court became aware of this, it was corrected. Heads of bench and I have been travelling to courthouses to speak to the profession, to hear what their experience is, and to see how the courts around the region in which we are located are functioning. And this has been invaluable, and we have taken what we have heard and we have fed it into our actions and our plans. We're grateful to the profession for the care taken in identifying issues as they have arisen. Since early March, we have worked with the profession as we have met each new situation and challenge. We've been helped a great deal in this by the New Zealand Law Society, and I acknowledge in particular the work of President Tiana Ipati. I also mentioned the New Zealand Bar Association, the Criminal Bar Association, and the Auckland District Law Society, each of which have done work to ensure that the concerns of the profession are brought to our attention. I'm shortly going to hand over to Justice Kāhui Miller, who's chair of the Judicial Steering Group, and I should explain to you what that is. This Judicial Steering Group's work has enabled the courts to move at speed and coherently to meet the needs of each alert level. Its task is to identify critical constraints on the court's capacity and to work to see them addressed. Justice Miller has worked with me and with the heads of bench and the Ministry of Justice to ensure that strategic issues are addressed and addressed in a proper priority. And it is through the work of the Judicial Steering Group, working closely with the heads of bench, that we have been able to communicate with you on a whole of courts basis. But before I close my general remarks, I'd like to say something about the shape of the court system and what this emergency has meant for it and will mean for it in future. In early March of this year, we had a court system based around courthouses throughout New Zealand. Proceedings took place largely on a kanohi basis, face-to-face basis. Telephone hearings were used in civil matters. AVL was mainly used in criminal proceedings and only for procedural appearances. Our files were paper-based, and filing was of paper documents with only limited exceptions. The experience of the last several weeks has been hard, but it has shown us the good and the bad of operating in our old way and in our new way on a more remote, less face-to-face basis. There are aspects of the good of this new way of operating that we will wish to keep. What is important is that the courts stay connected to the communities they serve, and that we work in the best way we can to ensure access to the courts, and in a manner which enables proper participation and respects the values of our society and our law, respects fairness, human dignity, and the rule of law. Thank you.
All right. Kia ora koutou. We lawyers are used to operating in a world in which the limiting factor on the amount of work that courts can do is judge time. and courtroom availability. The epidemics imposed 2 additional constraints, which I want to talk about. They are staffing and the numbers of people we can accommodate in courthouses consistent with social distancing. It's also worsened constraints on judge time, as the Chief Justice has explained. So I'll begin with registry staffing. Initially under level 4, the ministry dropped that to about 15% of the normal complement. It's now been increased with social distancing and hygiene protocols in place, and with the delivery of laptops to some staff who are working from home. So as of yesterday, we had 611 of 904 staff working in registries or at home. So that's 67% of the workforce that's available to the courts. We'll continue to face constraints under level 3 because the registry areas in many courthouses can't maintain social distancing with a full complement of staff. But with the levels we now have, we're obviously in a position to do much more work than's been possible under level 4. Under level 3, the staff will process filings and schedule hearings for non-witness or on the papers work, which had been a particular concern for the profession. It will also allow us to deploy some judges who haven't been able to come to court under level 4. The second issue is capacity of courthouses to accommodate people under social distancing. As you know, it's been necessary in order to carry on business at all that we close public counters and give priority to those who have business in courthouses. We've had to limit public access to maintain social distancing, much as supermarkets have had to do. And we expect that will continue under level 3 and possibly level 2. As we increase the number of hearings that we're running, the capacity of courtrooms and court precincts to accommodate people may constrain us, depending on how many courts we're running and what sort of business we're doing. It's a courthouse by courthouse question. We can't really gauge the limits in advance. We just have to start working and keep increasing the volume of business until we run up against them. There are ways of working around constraints. We'll use remote participation for as many hearings as feasible. For cases that are heard in a courtroom, we may schedule specific appointment times and encourage some participants to appear remotely. It will all help to increase the throughput of cases. To do this, we will need to devolve control to the local level because every courthouse is different. List judges will work with their local registrars to schedule business with registry staffing and courthouse layout in mind. Now that brings me to IT, which is obviously a critical part of our response. I want to pay tribute to ministry staff here. We started from a very low base with paper files and limited capacity for remote participation. In a couple of weeks, the ministry have equipped 65 courtrooms with Cisco Jabber VMRs. And as you know, those are being used to conduct a great deal of priority and other business in the trial and appellate courts. The ministry is now trialling Microsoft Teams. And as with VMRs, the initial focus will be on the district and family courts where the social need is greatest. The trial is to begin in the district court at Hamilton very soon. Teams will offer improved functionality for filing, scheduling and rostering, and the conduct of hearings. Some of you may know that Microsoft Teams is a cloud-based system. It uses Skype for business as its video conferencing platform and SharePoint for document sharing. For those who practice in the civil arena, that functionality will permit filing of large files or internally indexed and hyperlinked casebooks. The registrar sets up a domain and sends counsel a link which permits them to upload their documents, and they're then downloaded onto the court file. Our objective is to roll teams out as broadly as possible and as quickly as possible. The principal obstacle in that is likely to be getting the processes settled in registries which, as I've said, are understaffed and under pressure. You will need to bear with us because staff will be learning how to administer the system in real time. So I'll conclude these remarks by saying that while the Ministry and the courts have long aspired to have electronic filing, it's not settled that Microsoft Teams will be the permanent platform. There are jurisdictional and security risks associated with any platform using servers located offshore, and those risks have not gone away. I'm not suggesting that we'll revert to paper. Rather, I'm letting you know that the long-term repository for court records has not yet been identified. Aotearoa, that's enough from me, I think.
Thank you, Justice Miller. So I'll now go to the Chief Justice for some specific questions that I have for her. Chief Justice, I'm going to skip over the first question that we had planned about what the courts will look like at level 3 and level 2, and instead ask those of the specific heads of bench in each jurisdiction. I'm going to go straight to question 2. The decision to suspend jury trials until 31 July was met with some media attention. It certainly was met with quite a strong reaction from the profession, and understandably there was concern for both defendants and victims. Can you just unpack the thinking behind that decision and the factors that were considered?
Yes, well, the decision to suspend jury trials was taken because it's currently not possible to conduct them and comply with the requirements of physical distancing. The 2-month estimate reflected the fact that juries are summoned a long way out, approximately 6 weeks out, and the summoning of a jury at a time when there are such restrictions causes confusion and distress. So even though we have uncertainty about what the restrictions will be in 6 weeks' time, we have to factor in how that summons will arrive in the juror's household. It also places stress on the court systems because of the level of inquiry that it generates if it arrives in that way. In making this decision, we also took into account the level of concern there was with running jury trials before we were even at level 2, and that was concern which was primarily generated from the profession. Jury service is also a demanding requirement to make of the public, and I don't consider it's appropriate to place jurors who are providing such a service at risk or to cause them distress. It is, however, a decision that we can revisit should it become apparent that we do incredibly well, and it looks like New Zealand's going to be completely coronavirus free, and we can see that clearly at an earlier date. That's something we can revisit. However, ultimately, as it was in March this year, this is a decision for the judiciary because of the very particular requirements we make of juries. So when we factor in the general advice of the Ministry of Health, we have to take into account the very unusual nature of jury service, how intimate it really is in terms of physical space and length of exposure to each other.
And as you've said, even if we quickly go into level 2 or level 1, unlikely, but even if we're quickly there, we still need that 6-week summons lead-in time before we can begin jury trials.
Yes.
Yeah. No, thank you. The next question that was sent in by the profession was, are you concerned that the judiciary and heads of bench may lack the power to respond to the epidemic? And the concern provided as an example was the decision announced closing the criminal courts to the public and the statement by a principal family court judge around parental access, which appeared, according to this person asking the question, not to have a legislative basis.
Right, so I'll confine myself issues of general powers and to my own actions. The courts have an inherent jurisdiction, senior courts have inherent jurisdiction, all courts have inherent powers to ensure that justice can continue to be administered. And that has to exist because the courts face so many and varied circumstances. They must have the ability to move to ensure that justice can continue to be administered. We also have power under Section 24 of the Epidemics Preparedness Act, but that power only came into force once the epidemics notices were in force, and there was some delay between the lockdown and that.
Yeah.
But Section 24 allows the courts to modify any rule of court to the extent necessary to take into account a quarantinable disease. When I made my decision to restrict public access to the courts, I was acting in concert with the heads of bench to exercise inherent power to regulate the precincts of the courthouse to ensure that justice could continue to be administered in those courthouses whilst keeping those who are there for the business of the courts safe. There are other issues that are constraints on how the court operate. There is constraint on the ability to use remote technology to conduct some criminal proceedings. Only procedural matters can be conducted with remote technology. There's also the constraint that we have operating at the moment in respect of jury trials. Both of those things are constraints which really engage very fundamental values under the New Zealand Bill of Rights Act, and there is no suggestion at this present time from the judiciary that those should be changed, because it does engage such very fundamental, they do engage such very fundamental values for the court system.
Okay. Can I just ask you about court protocol and etiquette while appearing remotely? And I think a lot of the questions were concerned about standing up on screen or not, expectation of dress standards and general etiquette.
Yes. So there's no robes required when you appear remotely, but formal business attire is appropriate. You do not need to stand up because, as we know, those who appear in the Court of Appeal, who worked in the Court of Appeal, know counsel standing up usually means the court sees their belly button area, as opposed to please don't stand up.
Okay.
Take care to have your workspace set up appropriately and to avoid disturbance. Make sure you check out with the viewers so you don't have your flatmates caught an image in a partial state of distress, undress or something like that. Read the information that each court provides, so as to how you access remote technology, because once you're familiar with it, it makes it go much easier for everybody. Follow the usual rules that apply during hearings, and there's one peculiarity about remote technology, which is that it's harder to take a point if you're not on your feet, because you can't just stand up. So my suggestion is, and it seems rude to interrupt the person who's speaking, is to raise your hand up in front towards the screen to signal that there is a point of clarification you wish to make, or an objection, but keep those to a minimum.
There's obviously a debate, and I can see it coming through in the profession around remote. Obviously there's a school of thought that thinks remote hearings is great, let's do everything electronically, versus in-person court attendance.
Yes.
And I want to refer more specifically to the civil jurisdiction, because it's not as much a debate in the criminal jurisdiction. Do we know enough about conducting online hearings compared with physical hearings to be sure that the quality of justice in civil matters is not compromised? In other words, do we have any evidence to suggest that there are some matters that are best determined in person versus an online option?
So we actually know quite a lot about conducting civil proceedings remotely, because we've been doing it for a long time, taking witness evidence. We've certainly been conducting interlocutory matters of a simple nature on the phone for quite a few years. We use AVL to take evidence from people overseas to facilitate people who are unwell, who can't come to court. So we know quite a lot about it. We know that it has its limits. We know that it's difficult to conduct long hearings, complex hearings on AVL. For one thing, document sharing is more difficult, although, as Justice Miller's highlighted, there is now technology being developed which enables that to occur much more readily. We also know that technology can drop out, can have complexity. And we also know that it's very tiring and it takes longer to do business on technology. As to whether there are certain matters that shouldn't be conducted on technology, there's a lot of research as to its impact. The first thing is, I don't think if everybody's remote, there's no sense that there's anything other than an even playing field. But even if one party is participating remotely and another party is in person, judges are sophisticated users of this technology, so that's not likely to impact adversely on the person who's joining remotely in terms of the judge's assessment of them or their arguments. But we do know that some people find participating remotely difficult. We know that from a volume of research, which has been undertaken mainly in the criminal jurisdiction, but is relevant also in the civil jurisdiction. And that includes people with linguistic and neurological deficits who find it very difficult to participate remotely because of the number of inputs that they're getting, and also because it's disorientating to be on a screen appearing in some context, knowing you're being projected into some context you don't understand.
When we go to the wrap up at the end, I'll talk to you a little bit more about the return to business as usual, but just so that people watching know, we're going to talk about, because we're doing more and more remotely, what we might expect though with this new way that we're conducting business. And finally, before we go to Justice Miller, lawyers are concerned about civil proceedings being subject to the Limitation Act expiry. Has there been any thought about a reasonable approach to civil proceedings which aren't issued within the lockdown, which are subject to expiry?
Well, that's a statutory provision. And during the Canterbury earthquake, there was Section 82 of the Canterbury Earthquake Recovery Act was enacted to enable a solution to Limitation Act problems which were caused by the fact that lawyers could not get to their files. They were in buildings from which they were cut off. There has not been a similar piece of legislation enacted in this time. I think it's bound to be under consideration. It's certainly something I think the profession and the judiciary have raised with the Ministry of Justice as a possible.
We certainly have, yes.
And in fact, there are really very hard statutory dates that are of concern in the insolvency area in particular, which the courts have no ability to extend. So those are matters that have been taken up. But even in the area of limitation, that the existing statutory model, Section 82, creates discretion for court to extend. And unless you have good reason in this environment not to just ping in a statement of claim, you need to explain why this has stopped you complying with the Limitation Act this period of time.
Okay, thank you, Chief Justice. We'll come back to you at the end for wrap-up questions. Moving to Justice Miller. So first question for you, Justice Miller, have the courts considered online hearings, where appropriate, being streamed online so that family members and other interested members of the public can observe the proceedings?
Yes, live streaming is under consideration to compensate for the limitations on public access to courthouses. It isn't appropriate for every case, obviously, and where some protected or privacy interest is engaged, it imposes additional burdens on judges, counsel and staff to monitor what's being streamed. For those reasons, we've deferred decisions about it in favour of getting courts running. We have made sure that media who retain their right to appear have provision to join video feeds as proxies for the public, and victims are able to participate by audio. So that's where it sits at the moment.
Thank you. A number of members of the profession have pointed out the broad ability to conduct remote hearings under the Court's Remote Participation Act. And so this next question, I've kind of consolidated a number of queries. But the question was, would the court support a wider use of technology platforms such as Zoom and Skype for court hearings, judges appearing remotely and defendants appearing remotely, assuming that identity can be established? I know you, in your introductory remarks, you've already touched on this, but it would be helpful just to answer this question directly.
Sure. Microsoft Teams does use Skype for Business. You just enter a hearing by clicking on a link that's been emailed to you. And in principle, any participant might be permitted to appear in that way from any location, provided they have the technical capability and they're in a suitable place. So it's a case-by-case decision that will be guided by the sort of considerations that the Chief Justice mentioned. We have used Zoom for some internal work. There are concerns, as everyone will know, about the vulnerability of Zoom to hacking. And our focus is on Teams because of its ability to offer an end-to-end service, if you like, in which we have good document sharing and as high a level of security as we can reasonably expect from a cloud-based service.
And I think you've already answered the next question, which is arrangements around receiving documents electronically. I think you said Microsoft Teams uses SharePoint?
That's right, and Council will be told when it's available to them to file documents electronically in that way. In the meantime, you shouldn't make the attempt. We just don't have the capacity to take them at the moment.
And I think you've already answered question 11, which was again around, security reasons for not being able to use Dropbox.
Yes, the registrar was right to reject the filing of that bundle by Dropbox link. It remains the case that until SharePoint is in place, the only way in which casebooks can be filed is by delivering a thumb drive. You need to get in touch with the registry and explain that that's coming. There isn't anything to stop council sharing bundles among themselves via Dropbox or any other service that they choose to use.
And just so we understand, the question that we're referring to was yesterday a High Court registrar rejected for filing a court bundle by Dropbox link for security reasons. And I take it that with Microsoft Teams, this answers the next question, which is around presiding judicial officers having access to all the paper files and documents for hearings.
Yes, we're in a difficult position because for a time our court files are going to be a hybrid of electronic and paper. So presiding judges will have access to paper filed before the lockdown and electronic access to documents filed since. At present in the High Court, council should continue to file electronic bundles using thumb drives. And the rules, because this question asked about whether it was necessary to continue to prepare paper bundles, the rules also require a paper copy which is needed for archiving purposes. And we're working on that one with the ministry. For the moment, practitioners should assume that they must still create one at some point. To the extent you can't do it right now because copying and binding services are unavailable, you can make arrangements to delay filing of the paper copy. I expect that would happen by consent and the court would readily endorse it.
Thank you, that's very helpful. So we'll now move to the High Court. Justice Venning, if I can just ask you to provide some introductory remarks about the High Court jurisdiction, please. And obviously Justice Thomas will also be speaking in this section as well.
Thank you, Tiana. With the imposition of Alert Level 4 at short notice, the court was faced with a number of constraints in the work it could do. Initially, the work was limited to priority proceedings that satisfied the criteria identified by the Chief Justice of liberty, personal safety and well-being, and time-critical matters. After the first week or so under the lockdown, the court was able to revise its position and provided an update to the profession on the 2nd of April. The court will provide a further update by way of a practice note for its operation at Alert Level 3 early next week. About 35 to 40% of the court's work is criminal. A major portion of that is criminal jury trials. Obviously, the court is presently physically unable to run jury trials for the reasons the Chief Justice has outlined. And that will continue, and we will not be able to conduct jury trials under Alert Level 3. It is important, though, to emphasise that the court has been conducting other criminal work throughout Alert Level 4 and will continue to do so. It's been conducting first appearances in Category 4 matters, case review hearings, bail applications and appeals, conviction and sentence appeals, and also intends to deal with sentence indications, pre-trial matters, and sentencing. The remaining 60 to 65% of the court's work is civil or commercial. To provide certainty to the profession and parties, the court advised that civil trials involving witnesses scheduled to be heard before 25 May were not required to proceed. However, counsel were encouraged, and I repeat this, to nominate their case to be heard remotely if that was appropriate and if counsel were able to agree on that. They should let the local registrar know, and that will be accommodated. Other civil work of the court, particularly Banco work, has continued through Alert Level 4 and will be expanded under Alert Level 3. It's important also that the profession be aware that the Rules Committee has urgently passed High Court amendment rules that have practical effect all council should be aware of. The rules and explanatory paper attached or accompanying the rules are on the Courts of New Zealand website on the COVID-19 section under the High Court. In summary, the rules provide and deal with electronic filing, electronic signatures, service of documents electronically, authorisation for the use of unsworn affidavits in certain circumstances, and also confirm the power of a judge to control the manner of participation at a hearing or trial. Just generally looking at the operation of the High Court, I'm sure profession are aware that in each of the 4 home centres, Auckland, Wellington and Christchurch, there are civil list judges who are responsible for the management of the civil work in the court, and criminal list judges. At this time, and to support the position of the Chief High Court Judge going forwards, and to support the work of the court, I've established a civil work committee and a criminal work committee. The Civil Work Committee is chaired by Justice Lang and has the 3 civil list judges from Auckland, Wellington and Christchurch. That's now Justice Moore, Justice Mallon and Justice Dunningham on it. And the Criminal Work Committee is chaired by Justice Thomas and has the 3 criminal list judges. That's Justice Fitzgerald now in Auckland, Justice France in Wellington, and Justice Mander in Christchurch on that committee. And I'll just ask Justice Thomas now to say a few words about that committee and its operation.
Thank you. The Chief Justice has also established a criminal committee which reports directly to her, comprising judges from both the District and High Courts and Justice William Young. It is co-chaired by Chief District Court Judge Tumanu and me, and also attended by representatives from the Ministry. Its purpose is to identify criminal work that can be done at the various alert levels and the appropriate processes, including remote participation. It identifies constraints and how they can be addressed, and is looking at ways in which the courts can work together and how the Ministry can assist. It's also looking at issues with jury trials, for example, how we might achieve physical distancing. And then it's looking to the likely situation further out and planning for that.
Thank you, Justice Thomas. So, I mean, a lot of the introductory remarks do answer the question around what the High Court will look like at levels 3 and 2. Perhaps maybe to summarise it, and I'll direct this to you, Justice Venning. Obviously, no jury trials at level 3, unlikely level 2, unless some sort of strategy can be worked out around social distancing. But can we generally expect a lot more business to be going through the High Court in the civil jurisdiction?
Yes, indeed. At alert level 3, the court, well, I intend the court will operate with almost a full complement of those judges and associates and clerks who can work safely, but only from the 3 home registries at that time.
Okay.
The constraint will, as Justice Miller, I think, made the point, be the number of registry staff available to support court hearings and the physical distancing that the relevant alert levels will require. Judges will still not be, under alert level 3, able to travel to circuit registries, but circuit business will be conducted by remote participation. While there will be no criminal jury trials, as discussed,
I think we lost you there, Justice Venning. Justice Thomas, perhaps you could. I've lost both of them. Oh no.
I'm here.
Okay.
Here.
I think Justice Venning was just about to say, well, we're not going to conduct criminal jury trials.
participation in those hearings will generally be by remote participation.
Right. Sorry, Justice Venning, we lost you for a little bit there.
Right.
Essentially, you're saying we're going to be still doing criminal work, but everything other than the criminal jury trial.
Yes, and in relation to civil work, it will be business as much as can safely be supported, and that will be civil appeals, judicial reviews, summary judgments, caveats, interlocutory applications, injunctions, originating applications, and again, participation in those hearings will largely be remotely. The court also will resume hearing civil cases with witnesses from the 25th of May and earlier than the 25th of May if counsel agree their case is ready to proceed and can proceed. At level 3, the list courts will resume and there will be bankruptcy and liquidation lists run, but of course the court will amend its practices where in-person hearings are required or people are required to attend the court. The hearings will be held in the largest courtrooms we have available and to provide physical distancing, and where there are appearances of a number of parties such as in list courts, the courts will operate on a case-by-case call basis with parties waiting outside the courtroom, a little bit like people wait outside the supermarket now, and then be called into the court when their matter is to be dealt with. At present, I anticipate the major difference between alert level 3 and level 2 will be that judges will be able to travel to circuit registries to conduct hearings that require in-person attendance.
Okay. Thank you. I just want to quickly deal with backlog. We've got quite a few questions from the profession about dealing with backlog and prioritising. Obviously, you've already set out what can proceed and what can't proceed, so that almost is a prioritising in of itself. Other than the usual triaging factors that we would normally apply to cases in backlog, are there any other criteria that will be applied in this context that we're now living in?
Well, no. The number of cases, both criminal and civil, that have been adjourned, while significant, are still sufficiently limited in the High Court at least, that each case will be able to be reviewed by a judge to determine what priority should be given to it in terms of reallocating a hearing for it. The usual criteria for priority civil cases, such as injunctive relief or transactions depending on the outcome, business dependent, matters of that kind, will be taken into account. And in criminal cases, I expect that judges will take into account the usual criteria of vulnerable witnesses or complainants, that sort of thing. So those criteria will apply to the reallocation of the adjourned cases. Would you like me to go on and answer your next question, Tiana?
Yes, sure, please do.
Another one's been asked. Another question is asked is whether civil cases will have to wait until criminal and immigration cases are completed. I don't anticipate that there will be any delay in dealing with any immigration cases. We are dealing with judicial review and appeals now. So if they're scheduled to be heard, they will proceed. The principal constraint in relation to dealing with the criminal cases will be whether Level 2 permits criminal jury trials to proceed as you've outlined. And a particular constraint in relation to catching up with the backlog of criminal jury cases is, again, as Justice Miller highlighted, the physical courtroom requirements. In any courthouse, there are a limited number of jury-capable courtrooms for a starting point. So those are constraints for us. In terms of what information we can provide the profession about the cases that have been adjourned, as I've said, each case will be reviewed by a judge. A minute will issue, or where appropriate, a conference will be held with counsel. We've got sufficient judicial resource to do that, and as I've said, the number of cases adjourned are limited enough to enable us to do that. An issue of real concern, I know, is that what's going to happen to those cases that have been vacated or adjourned since the lockdown through to when we resume hearings, the 25 March, or in the case of civil cases, or August jury trials. At present, there is no intention to reschedule cases currently scheduled for August in civil and criminal cases, or after 25 May for civil cases, to slot in those adjourned cases. It's just administratively would create a bigger problem than we have at the moment.
Yeah.
We've got counsel, parties, witnesses ready to proceed on scheduled dates, and to the extent we can keep those dates, we will. And so for that reason, there's not going to be any general call over or status hearings to reallocate cases. But the good news is that with no jury trials until August, and with most civil fixtures until 25 May vacated, the work that we've lost from the date of the lockdown to now will be able to be backfilled into those dates in May, for instance, in civil cases. And we are also obviously looking at using the time that was available for criminal jury matters to deal with and to put back in criminal pre-trials that, for instance, were vacated at the initial stages of the lockdown. And I think Justice Thomas has been giving some thought to this matter as well. So I just ask her if she's got anything she'd like to add to that.
Just to say that in respect of the adjourned criminal trials, judges have been reviewing them, issuing minutes and convening conferences where necessary. We're also looking for counsel to be proactive, requesting sentence indications, for example, or identifying pre-trial issues, because that is work that we can get on with now.
Okay, thank you for that. Well, I'm going to finish High Court jurisdiction with just one question, because I think a lot of the information you've provided answers some of the other questions we were going to deal with, and just go directly to probate. There's obviously been quite a lot of feedback that we've received from the profession about probate not being processed during Alert Level 4. Will this change in Alert Level 3?
Short answer is, as from Monday, even before there's any further announcement by the government, probate office will be up and running and probates will be processed.
Great. So irrespective of us changing to Alert Level 3, probate will be dealt with
from Monday the 20th. Yep.
Thank you. Thank you very much. Thank you very much, Justice Venning and Justice Thomas. And I am going to move now to the Chief District Court Judge, because we've got quite a lot of questions for him and we need to move on with time. So, Chief Judge Taumanu, if I could just ask you to make some introductory remarks.
Kia ora, Tiana. Tēnā koutou. As everyone is going to be aware, we've been running a restricted operation in the District Court over the period of the Alert Level 4 lockdown. And we are now facing a large volume of cases that have been administratively adjourned. Prior to the lockdown, our court was developing creative solutions to address the backlogs, and so the lockdown has obviously added to the backlog that our court is currently facing. And I just want to be clear, the word backlog is a shorthand way of describing people who are waiting for their cases to be heard by our court. We're often described as the People's Court, and we recognise the significant human impact that is caused by delays in having cases heard. When the new level 3 restrictions come into effect, I will be directing that the District Court resume undertaking as much of its work as possible. There will still be limitations that will apply, and they've been really referred to by many of the previous speakers, and so I won't go into detail about those limitations, but the intention is to do as much of our usual work as possible. In all jurisdictions, the nature and extent of our operations will be limited by various factors, and I think it is worth explaining what some of those factors may be so that the profession does understand. We may be operating with a reduced judicial capacity. Some of our judges who are elderly or have vulnerable circumstances may in fact be unable to preside in person in courtrooms. It remains to be seen at this stage how many will fall into that category. But for those judges who might not be able to preside in person, we are exploring how they can use virtual technology to work from home. And that's something that Justice Miller has already referred to. The number of Ministry of Justice staff has been referred to already by other speakers, and so I won't go into much detail about it, except the physical distancing requirements that will need to be observed by those staff will have some impact on our ability to operate. But it is, of course, and I want to make this point, untenable that the safety of ministry staff is compromised, and it's also likely that staffing levels for police, corrections, forensics and other stakeholders will be reduced in similar fashion. And the same probably applies to members of the profession who would ordinarily have no difficulty appearing in person in court. So these are things that are going to impact on the ability to carry on at full capacity. It's necessary for our court in particular to consider creative solutions to confront and overcome the challenges that we face. And the particular challenge that we are facing is that one I've mentioned already of backlogs. The double sessions model, which has operated in Manukau for some time, is a model that may need to be explored further. And in terms of other possibilities that may be for discussion at some point, it might include some of our courts sitting and doing regular work on Saturdays, but these are matters that we need to think through as solutions to an issue that's not going to go away anytime soon. A one-size-fits-all approach simply won't work in the district court. A range of approaches involving local initiatives will be required, and it will require our executive judges and our liaison judges to actively work with the local registry, the local profession and the local stakeholders to develop responses that best address the needs of their individual courts. Local judges will be invited by me to direct rostering and scheduling that ensures the best utilisation of our judicial resource in accordance with priorities that are set by heads of bench. Judges, judicial resource managers, regional schedulers and court managers will all play their part to develop local solutions that will address local issues, and I would suggest that the profession has a role to play in these local solutions in the courts that we all operate in.
Can I, obviously before the lockdown, there was a number of cases. Backlog is the term that the profession have used in questioning, but these are people. Delay is stressful. Has any thought been given to courts running on weekends and evenings? And I appreciate this is a totally left field question that I hadn't prepared for you. But has any thought been given to that, to going outside of normal operating hours?
Well, those ideas are obviously what I've just referred to in terms of double sessions and potentially working on Saturdays.
I see.
They're ideas that are going to be explored, Tiana, but I'm not signalling at this stage firmly that they're going to happen, but they certainly are going to be explored.
So in terms, I'll ask the same question I asked of Justice Benning. Are there going to be any other method of triaging cases other than the normal types of factors we would apply?
Well, it's worth bearing in mind that at the moment, for the last week in April and the 4 weeks in May, it's intended that all of the scheduled work, or as much of it as possible, will still be conducted by the District Court. And at the same time, liaison judges will be conducting reviews of the files, particularly those that were administratively adjourned, and will be looking to bring forward the priority cases that have been administratively adjourned. If necessary, there's going to need to be call-overs involved in this period after alert level 3 comes into effect. So the priority process has already been described by Justice Benning, and it's going to be the same in the District Court. Priority will be accorded to cases that affect liberty of the individual, vulnerable witnesses, cases that affect safety and well-being, and also cases that are time critical.
So we'll be doing judge alone trials in alert level 3?
That is the plan, yes. We'll have to observe physical distancing. One thing that's probably going to have to be made very clear is early next week, alert level 3 protocol will be issued by the District Court, and it will outline how physical distancing is going to affect the court, because there are going to be real changes to the way that these cases have to be dealt with to observe those requirements.
And this all leads to the next question that we have written down, which is, can we expect the grand call-overs or status type hearing call-throughs to try and determine, or will counsel just be issued with notices from the registry office saying, we've identified your matter as a priority matter, we're asking that it be brought forward to this date?
You can expect call-overs of quite a grand scale.
Right.
Yes, by the individual liaison judges in connection with the local courts, because as I mentioned before, one size won't fit all in dealing with this issue that's arisen. There has to be local initiatives, and they'll be led by the local liaison judges.
Okay. I'm going to move on to question 23, Judge Taumanu, unless there's anything else you'd like to add, just because I want to make sure we allow time for family court jurisdiction.
Sure.
So the question that we've got at 23 is, will the District Court start using email and telephone technology as envisaged by the purpose of Section 3B of the Criminal Procedure Act, and that, you know, that there are a whole lot of administrative matters that just get dealt with on the papers. So, for example, call-overs to obtain judge-alone dates, case review hearings that don't require judicial intervention, and list call-throughs for judge-alone trials.
The answer to all three questions is relatively simple from my point of view. It will be a matter for the liaison judges to determine the most effective means of conducting those types of hearings.
Okay, thank you. There was a question about counsel presently appearing by telephone linked to a speakerphone in court. Some lawyers can only hear about 20% of what the District Court judge is saying. If those links are to continue, can that speakerphone be moved closer to the judge, or the facility upgraded? And previous feedback that I've received also suggested perhaps a lapel microphone for the judge.
Tiana, the other day, I think it might have been Wednesday, the Chief Justice and I were actually out at Waitakere District Court and observed a hearing where this exact issue arose. And in the end, the judge involved did his best to achieve a satisfactory result. And there were difficulties. It was frustrating, not only no doubt for the presiding judge, but it was just frustrating to watch the difficulties that were at play. But with perseverance and patience, the technology eventually was able to be used in a way that communication was possible. And I would suggest that this is really the key to the changes that we're undergoing at the moment. We do need to be patient, but we also need to persevere.
There's been recent changes to the High Court rules to cater for lockdown and other restrictions. The question is, will there be similar amendments to the rules of other courts, in particular district and family courts?
Well, I'll restrict myself to talking about the district court generally, and we have engaged the legislation and rules committees on this point. And what I can say about this is that it is intended that the district court will establish a regime that reflects the High Court amended rules to the extent applicable to the district court.
I'm just going to skip to question 27. The Chief Justice guidelines issued to date advise that where a defendant is in custody and due to be sentenced, that is a priority sentencing. If the matter is called in the district court and adjourned as the judge has not read the file, should the adjournment be shorter than 3 months? It's quite a specific question.
It is a specific question, but I want to give a general answer to begin with.
Yeah.
Custody sentencing is a priority matter. There's been a project established recently in the district court to bring forward custody sentencing once the court is notified that the pre-sentence report is ready. And those sentencings are being brought forward to the next available date. The example that's mentioned in the question should be heard at the earliest available date convenient to the parties.
You may want to give a more general answer to the next question too, which is around bail hearings. There appears to be in some regions around the country the inability, I'll put it, to hear opposed bail hearings or on an urgent basis. And the question is, can it be heard in advance of what's normally scheduled or from a judge in a different region?
I will give a general answer, but it's quite a firm one. Judges will be made available to hear bail applications, and there is capacity to have judges hear bail applications from a remote location where local judges are not available.
And lawyers have been getting knocked back on just by consent bail variations. Is this correct? And if it's not, then what should be the procedure for getting signed and sending in agreed variations?
Well, the answer to question, is it 29 that I'm looking at here?
Yep, it's 29.
Question 29. This is not correct.
Right.
The ministry have actually designed a process, and it should be accessible by the profession either by making an inquiry of the ministry or just looking at the website.
Okay, and that's the Courts of New Zealand website, www.courtsofnewzealand.govt.nz.
Well, that's one website, but the one I'm thinking about is the Ministry of Justice website.
Oh, okay.
It should be on there somewhere, Tiana.
All right, thank you. There was a question about lawyers being able to talk to their clients, kanohe te kanohe, but I think that's largely been answered by the latest communication from corrections. So that for those of you who are listening and want to know about that, that letter dated 15 April is available on the NZLS website now. I'll go to questions 31 and 32. These two questions came from Korimako Legal Education, who are a group of Māori lawyers who are currently running a Facebook page providing user-friendly information on District Court and Family Court. And I'll start with the first question. COVID-19 is causing anxiety with a number of communities, particularly marginalised communities who face adversity outside of COVID-19, i.e. our Māori communities. What role will judges, particularly in the district and family courts, play alongside the profession in engaging proactively to ensure that messages about the court's operations get directly to those communities, including through the use of accessible forms of communication such as social media?
Well, this is an idea that we are carefully considering at the moment, Tiana, and haven't at this stage worked out exactly how this is going to be done. But in principle, it does need careful consideration about how it might be done appropriately.
The next question is that COVID-19 has highlighted there are some opportunities to change business as usual, particularly in the district and family courts. Moving forward, what is the plan for judges to engage with the Māori community in accordance with Te Tiriti o Waitangi to take advantage of opportunities to change business as usual?
Well, prior to the advent of the COVID pandemic, the vision for the district court really included and substantive fairness. And also there was quite a clear indication before COVID came upon us that there would be an attempt to incorporate into mainstream courts the best practice lessons that are being learned in our specialist courts to the extent practicable. And this included quite a clear intention to invite the voice of iwi Māori into the courtroom, along with the wider community as well. So when alert levels are lifted completely, Tiana, it is my intention that the district court return to a kanohi ki te kanohi operating model. And there may, of course, be virtual technology practices that we adopt during this alert level regime that would be appropriate to continue on into the future. But a face-to-face kanohi ki te kanohi model is one that we will be returning to when this is over.
Thank you, Chief District Court Judge. We'll now move to Family Court Jurisdiction, Principal Family Court Judge Moran. Whakai, I could now invite you to make some introductory remarks about your particular court jurisdiction.
Kia ora koutou. In contemplation of the restrictions imposed by Alert Level 4, the Family Court identified the priority work to be undertaken. And given the nature of the work we do, that was extensive. It related to proceedings concerning safety and welfare of people, particularly children and the most vulnerable. It also covered proceedings that were time limited. They have all been dealt with, and they've been filed and dealt with on our duty platform. We had anticipated a spike in family violence, and particularly in the numbers of applications for protection orders. We also anticipated that there would be an increase in the number of applications for parenting orders and variations of parenting orders, particularly with the level of concern that was evident both immediately before and going into lockdown. Okay, sorry.
I think the sound quality is, oh, you've muted yourself. That's it, that's better.
Okay, is it?
Yes.
Right. Will I carry on now and see how you hear it? Okay.
Yes.
So we had anticipated an increase in protection order applications. We had anticipated an increase in parenting order applications because of the concerns expressed by the community about what was going to happen within the bubble and the like. This not only didn't eventuate, but in fact, we have the opposite. By way of example, there were 47% fewer applications for protection orders, 60% fewer applications for parenting orders, and 86% fewer applications for variations this Wednesday than there were on the Wednesday 2 weeks preceding the commencement of Alert Level 2. So the reduction has been dramatic. The only exception to this has been in the area of mental health. The Ministry of Health reports that the trouble is within the bubbles themselves, and it's a very strong emerging theme. It's reflected in the applications for community and inpatient treatment orders that judges are dealing with. as we move out of the current alert level and down, it is anticipated that these specific trends will in fact be reversed, and the family court needs to be ready for this. So I have been working closely with my family court liaison judges and my advisory board members to determine how this will look at the various alert levels. The court will still focus on urgent matters, prioritising children's welfare and decisions for vulnerable, particularly for older people whose care needs be determined. Mental health hearings will continue to be undertaken remotely. As the family court is very strongly paper-based, it has been harshly impacted by the issues for registry staffing and the technological challenges. As the registry staff come back on stream and as Justice Miller has outlined, greater remote access will be available, then we can move forward with our work. Certainly we can expand what's being done. Family court judges are anxious to progress work to the extent possible. It is likely that in the immediate future, conferences can be scheduled to occur remotely, as can non-witness hearings. Conferencing and in-person fixtures will be possible but limited depending on the courtrooms and the ability to comply with the social distancing.
Thank you. I'll move directly to question 35 then, because you've answered a lot of the first two questions I was going to ask you, and whether the family court will give priority on matters with time pressure in the relationship property sphere.
Okay. All family court matters that were adjourned during alert level 4 will be reviewed by way of a triage process. So that will include any property relationship matters. If they are time pressured, then they will be prioritised along with all others, as will the likes of interim spousal maintenance and those sorts of proceedings. But it's important for lawyers to realise that the e-duty platform is still available for all without notice applications, and that includes property.
Okay, we're just going to switch to a photograph of Judge Moran to see if we can improve the sound quality. So can I just then ask, so to what, I mean, you've already partly answered that, but to what extent will we get maybe more case management of files by judges and measures to really resolve some of the work that may have been adjourned, but also the influx of work? So you mentioned that the family court workload had actually reduced quite a lot during the lockdown period. Part of that could be because family lawyers may not be able to operate in the same way in their bubble. So obviously there will be an expectation that as we come out of lockdown and lawyers are able to go to their offices, we might have an influx of work. So I just wanted to ask you about case management type controls and measures that might be brought in.
Prior to going into lockdown, the family court already had a huge number of cases that needed to be dealt with. We had just had the appointment of 12 new judges and were optimistic going forward, but we still have all of those cases, and we do anticipate that the people who have not been able to access justice for a number of reasons during this lockdown period will apply to the court for orders. To ensure that we address this effectively, there will be direct judge management of those files. What's anticipated is that judges will triage matters that were adjourned during the lockdown period often without any triaging at that point. Those files that were in the e-duty process during lockdown, the expected post-COVID surge, and work that is identified as urgent from any triage of box work files once they start to be undertaken by judges, which should be soon. It's anticipated that through this triage process, matters will then be sent to call through so that we can reprioritise. That's a process which will also involve lawyers, because that will assist us considerably if they can indicate where files are at, which have resolved and don't need to be called through, so that we are only dealing with those.
Oh, I think we've lost you, Judge Moran. Might just see. Right. Well, if we get the Principal Family Court Judge back, I'll ask. I only had one more question, and perhaps if I can go back to the Chief Justice. Chief Justice, we've just got some wrap-up questions that I would like to ask you, and they're obviously a very general nature, and they're appropriate for at this stage now that we're coming to the last couple of minutes of the webinar. And I thought this was a wonderful question that a practitioner sent in, and I'm sure, no doubt, all the judges will be happy to see this type of question. Practitioners are aware that the lockdown and the closure of the courts is going to put a lot of pressure on the courts and registry staff over the coming months. Is there anything that practitioners can do to assist?
Oh, well, the first thing they can do is speak to each other and cooperate and try and work things out themselves. The COVID-19 response is not an opportunity to throw out existing timetable orders. If the timetable orders are moving towards a hearing sometime in the distance, then council should continue to proceed through those. If they're accelerated for an early hearing and that hearing's not taking place, well, of course, council should be reasonable with each other and reach an accommodation. They shouldn't be coming to court to sort out what should be able to be sorted out between responsible counsel. They can inform themselves about the court processes. The courts of New Zealand is the single source of truth in terms of the operations of each court. They can stay up to date by, if they're Twitter users, going to the Courts of New Zealand Twitter site where everything that's new comes out will be tweeted out to them. And that way they don't have to tax the registry staff with questions that they can find out for themselves. In the future, we're going to be looking to innovate in the kind of ways that the courts operate. And the Chief Judge District Court spoke about that a little. We're going to need the cooperation of the profession in that. We're also going to we are very receptive to the profession's own ideas about how we can start this recovery process. And really, we have to start recovery now while we're still under alert level restrictions, because as has been said a lot of times, this is not a backlog. This is individual cases with an individual human cost to delay.
I think I'll just follow up that what you've said, Chief Justice, and I don't know that many of the profession understand that every day at 2 p.m. there's a Zoom Zooey between myself, President of the New Zealand Bar Association, Kate Davenport, President of the Criminal Bar Association, Len Anderson, and President of ADLS, Marie Dyberg. And every day we sit together and we consider all the remarks of the profession, and as you know, we feed them all to you and the rest of the heads of bench and indeed the judicial steering group. And I just appreciate that there's probably quite a few practitioners who may have sent questions through, and I can assure you that the judges have seen all your questions, and so they are aware of the concerns, and we will endeavour to answer specific questions in one form or another, whether we do another webinar panel or we come back to you with other comms. But I just wanted to assure the profession that their ideas, their concerns, their queries are being passed on.
Yes, and valued.
Thank you. So to the next general question is, the Chief Justice has indicated that following return to alert levels, we'll be back to business as usual in terms of default to in-person hearings across the board. While many in the profession applaud this position, and I do want to make that very clear because I've certainly seen the feedback, some are questioning whether we retain some of the gains that we've made during the lockdown. Are the courts really proposing a complete reversion to the way things were done? Or can we expect to retain some of what we have learnt when we're completely out of alert level restrictions? So this is quite a future focused type question.
Yes, so I've often talked about the desire to return to business as usual. And when I speak about that, I speak about a model of justice that operates in New Zealand, which I think we can be proud. We are fortunate that we have courthouses spread throughout New Zealand where the community can come and can see justice in operation, and where the community's values and services can feed into justice administered there. And the Chief Judge of the District Court talked about a vision we had before coronavirus hit us, that we would make justice more community-based by seeking the voices of that community coming into the courtroom more to support defendants, including the voice, and particularly the voice, of iwi. We hope to return to be able to have those courthouses as vibrant places where people see justice being administered, and we hope to have a presumptively, we will return to presumptively face-to-face, kanohi kite kanohi way of doing justice. And it's not just important for the way that justice is administered in every case. It's important because to support the rule of law, because you really do need, everyone needs to see the performance of justice, how it is performed, and that tells everybody, not just the people who are involved in that case, that you can seek justice before our courts in New Zealand. But of course we want to take the good from what we've learnt. We have long wanted to have electronic filing but have not been able to have it, and the judiciary is quite determined to try and secure electronic filing if we possibly can with support of the Ministry of Justice, and they want to see electronic filing too, I should say, come out of the end of this, because that is such a superior way for the courts to function. We also intend to continue to use remote technology where it's appropriate, improve access to the court, and to reduce costs to the parties of litigation and procedural matters, and even in substantive matters where that's appropriate. Because of course it costs to have counsel travel to a place, it costs parties to have the disruption to their lives they're travelling. So in some cases, remote technology is a great solution. But at the end, what we want is a system of justice that takes the good of the old and the new and retains the values I've spoken about already, values of openness, of fairness, and respect for human dignity, and that we arrive at a system of justice which is best designed to provide all with access to the protection of the law for our courts.
And just to pick up on, I know that Chief Judge Taumanu, he keeps referring, this is the People's Court. And I think it's important to keep remembering this is about people at the centre of all of this.
Yes. Right.
Well, thank you, everybody. Yes, with 1 minute to spare. That just leaves it for me to once again thank all the heads of bench who've joined us today. On behalf of the profession, I really do sincerely thank you all for the time that you've taken, not only just to make yourselves available in today's webinar, but the lead up to today. As I said at the beginning, a recording of this presentation will be made available through NZLS CLE, and you'll be sent an email that will include how to access it, your certificate of attendance, because this is all counts as CPD, link to an online evaluation, and we just ask that you take a couple of moments to complete the evaluation for us. Thank you to everyone who took the time to send in the questions, and thank you to all of you for being part of today's webinar. The New Zealand Law Society, together with the New Zealand Bar Association, the Criminal Bar Association, ADLS, we are all committed to bringing you up-to-date information from trusted sources on an ongoing basis. So please do keep checking the Courts of New Zealand website for updates. The Twitter that the Chief Justice mentioned before is @CourtsOfNZ. So if you want to follow the updates on Twitter, you can follow it there. Obviously, the New Zealand Law Society COVID-19 page for information on other aspects of legal practice. And I'll just finish with a whakatauki that I used in our latest edition of Law Points last night that went out with the special video that we shared of the signing of the Memorandum of Understanding with Te Hungaroa Māori. Noho tāwhiti tū kotahi. While we must sit apart right now, let us stand united. Kia kaha, kia maia, kia manawa nui.